and this is for replay. So we're going to start recording that. We share materials and video replay by email by the end of this today. So you'll be able to see that in the morning. If you have any questions, do type those questions in the chat, and we will do Q&A at the end of the session. Having said that, we are here, we're not providing any legal advice. And if you need any specific legal advice, well, you could reach out to us. Brad would be able to help separately, but we would recommend that you talk to your attorney. Now, having said that, let's do a quick introduction. Hi, Brad. Welcome.
Hi, DV. Hi, everybody. I'm Brad Hammer. I am Chief Privacy Officer at Essert. Glad to be here and talk about POPI. So,
Thank you.
And a little background on me. I've been practicing data privacy law for 10 plus years at this point now. So, gone through GDPR and all of the other laws, and now we're on to POPI. So,
absolutely, absolutely. Hi, my name is DV. I'm the founder and CEO of Essert. And I also wrote the book on the POPI Act. I've been an expert in security and privacy for a very long time. We also have JC Reddy, who is a co-founder and CTO. He's the one behind doing all the software needed to make it so easy for you to be compliant pretty fast. Okay. Having said that, what do we cover here, Brad? We're just going to talk about what is the POPI Act, what should you do with respect to getting compliant, the policies required, the manuals required, the planning needed. We're going to talk about the data subject rights and the requests from the data subjects and the data collection. How do you process it? Any special information or data that you process, how do you deal with that? Deal with data protection and security, preventing data breaches, obviously. And how do you implement this whole thing? The key takeaways from this, Brad, are going to be, right, you can get things done fast, right?
Right. Yep.
And you don't have to worry too much about it because right now, with the exception of your time, it's not costing you a dime, all right?
Exactly. Yep. Yeah, and,
so
and to do something, don't do nothing is also our big takeaway. So.
Absolutely, absolutely. So what is the POPI Act, right?
So POPI Act is sort of South Africa's answer to comprehensive privacy law, which is becoming more and more common around the world. GDPR being sort of one of, Europe being the leader in that space. But when I say comprehensive privacy law, it means that if you're processing any kind of personal information, regardless of what kind of entity you are, it applies to you. And the key here is that it's granting certain rights to individuals with regard to their data, as well as that you have to be responsive to it, as well as creating obligations on the businesses or groups or organizations that are processing data to make sure they're doing so in a compliant way and in a secure way. So,
absolutely, absolutely. And also make sure that you address the rights of those consumers. It applies to every company. It applies to public companies. It applies to public entities, private entities, non-profit organizations, everybody. Even if you're a sole proprietorship, it applies to you. Okay, so keep exactly. That in mind. This question comes up, oh, I'm only doing this, and does it apply to me? And yes, it does apply to you. Right.
Yep.
I'm going to skip this. I think many of you may already know. If you don't know already, it's already, the enforcement is set to begin already. It's been a year and the information regulator said they are going to enforce it. So watch out, right, primarily. Okay. Having said that, what is the information regulator going to do about it? They are likely to put some fines, and they haven't come out with any major fines so far at this particular point of time. And but Brad, I think in July sometime, the regulator announced saying, yeah, we've given enough time.
Yep.
It's a year since the act is effective, and we're going to start making sure that people actually adhere to it. To that effect, one of the annual reports that need to be submitted, I've seen the information tweet about it constantly saying, please submit your annual reports and please submit your annual reports, right?
Yep. I think that there was a time period where when it first went into effect, I would say that you had some time to get things figured out because the regulator was still getting organized, but we're reaching a point where the regulator's patience with you trying to figure out how to be POPI compliant will run out. And so that's to say, if you haven't done anything, don't panic, just start doing something. But certainly don't delay much longer, because it's getting to the point where they've not started actively aggressively finding people, giving people some time to get in compliance, but it'll start soon. So,
and also don't forget, if you do have a data breach, it'll cost you money.
Yeah.
Right. It'll cost you anywhere between R500,000 to 40 million rand, depending on the size of your company. The question, Brad, is not about whether you will likely have a data breach. The question is, when will you have a data breach?
Right.
Okay, so you need to address that, and the regulator is going to be on your back the moment you have that data breach. It's really important that you get compliant pretty fast. Okay,
Absolutely.
now having said that, what's the risk of a breach under the POPI Act? And this is a question that we get asked a lot, Brad. I mean, why should it cost so much? It's just a data breach. My business should not be impacted. That's not true. The businesses are impacted because under the POPI Act, you need to notify customers, and that is going to cost you money. The notification process itself is going to cost you money. And there is going to be an investigation from the regulator, because you do need to inform the regulator as well. And the regulators basically comes back and says, okay, how do we go about doing this? And obviously your recovery costs also comes into play. Okay, so all of these just add up, right? Somebody has their hand up. You could type your question in the chat, and as we talk, we can address that question. No problem. Okay, thank you. Now, having said that, the key, this is the question we get asked by all of our customers: when are they going to enforce? Are they enforcing? Right? Right? No, the information regulator is very well funded, and they're staffed for enforcement, and they are actually hiring a lot. So the fact that even if they open an investigation because somebody complained about you, that itself will cost you money. Because the moment they open the investigation, you've got to get an attorney to address it, or you have to do something from a process point of view to address it if you have not addressed it already, and you're going to rush through the process, that kind of stuff, right?
Yep.
Exactly. And we have seen the Information Regulator Act based on complaints from consumers.
Yep.
Right.
That's the most frequent way, at least in the initial stages, that someone's going to that you're going to potentially get an investigation by the regulator is if either one person, probably multiple people, are complaining about your data practices or something with regard to your notice, or something having to do with a potential violation of POPI. That's where they are going to start investigating, because that's they're going to want to address where consumers are impacted, because that's sort of the aim of the law, right? So, right.
Now, having said that, so we set the stage for why do you need to get compliant, right? Before I jump in, anybody, Theo, do you have a question? Your hand is up, so I was assuming that you do have a question. Do type it in the chat. Having said that, so let's just jump into how you get compliant. The most important thing to get compliant is about public notices, consent, and policies that you need to have together. Okay, and the second thing is, how do you process data subject rights? Data subjects in this context mean your customers, your leads, your B2B information, so your vendors, employees, candidates, job candidates for employment, any of that stuff, right? And the next thing to address is obviously in the area of data security and data protection. How are you protecting your data? Are you putting it in the right place? Are you securing it correctly? Are you doing encryption properly or not? That's more IT side of the equation. And the last one, and actually really useful one, is are you lawfully processing the data? You have you done the right disclosures, what data you're processing, and then you're processing it lawfully. So if you don't do any financial transactions, you don't need to have credit card information with you, as an example, right, Brad?
Exactly. I mean, it's taking a critical look at what you have and deciding if you need to have that information, and then, you know, as you covered as you went through that, it's thinking about it on sort of the two sides of the of it, which is the security side, so thinking through the technical pieces to make sure that you're securing the data, but also sort of the policies and procedures side to make sure that you have the right notices out there, that you're responsive and have procedures for people to go through if they do make requests, and that you're looking at your data flows and those pieces as well. So it's it's thinking about both aspects of that. You can't just do one. It's really both of those items. So
Absolutely. Now, having said that, how do you actually go about doing it step by step? And that's where we come into play, right? So this presentation will be available for you to review all of these steps. But the key elements really comes down to policies, public policies, maybe just-in-time notices, employee notices that you need to do, partner agreements and the customer agreements. In those partner and customer agreements, that you are actually asserting that you're compliant with the POPI Act. You need to have those in place, and then deploy the privacy rights management. So you need, if a consumer comes to you or one of your customers come to you and say, hey, you got my name incorrect, modify that, right? You need to go through that process, right? And from the data security perspective, obviously you need to talk to your IT folks and go through the inventory of the data you have. Have you secured it correctly? You know, all of that stuff is something that you do need to take care of. Okay. And from the processing point of view, simple things like registering with the information regulator are important. Do you have controls and mechanisms in place? Do you do training for your team that does go through the process of POPI compliance? Okay, so all of those also become really important. So we've broken this down into simpler steps, you know, for you to just simply get started and be done, at least on a peripheral basis, and we'll talk about that, right? Now, coming down to information officer, this is a really critical function defined under POPI, Brad, right?
yeah, so yeah, the information officer is a role that you have to appoint within your own organization, and then and because they have to have a certain level of sort of responsibility within the organization, and then the law defines the responsibilities that they need to have, as well as the level of sort of minimum expertise that they need to at least be informed about the POPI Act and what needs to be done with regard to compliance. So.
Right. So having said that, you know, typically the information regulator is basically saying the CEO, managing director of the company, need to be the information officer, or an executive. It should not be. And we checked this again. There was a question and comment some time back about this. We checked this again, that the information officer must be an employee of the company.
Yes, and so somebody just commented that PAEA allows that to be external, but PAEA is the law that came before POPI. And so you have to comply with both PAEA and POPI, and POPI has requirements that it be specifically for internal. So
yeah, and PAEA is now amended also slightly. I've briefly looked at the amendments on PAEA. So, you know, I would suggest you take a look at that too. Okay. Cool. Having said that, data collection, Brad, this is simple, useful, important. Do you collect information? Yes. If nothing, you're employing somebody, you're collecting information. You're selling to somebody, you're collecting their information. You're storing that information either on email or someplace. So there is information collection that you're doing, period. I mean, you need not have a CRM system, all these complicated systems. That's not the point. You're just collecting information, right? The more important thing, Brad, that POPI specifically prohibits is buying personal information, right?
Right. Yeah, I mean, the key behind POPI and the way it does this is that you have to have consent to be, well, it's particularly in the marketing space, which is where this is most frequently going to happen. You have to have consent in order to market to individuals and to contact them. And if you are purchasing a list, it is very likely that you do not have the type of specific and explicit consent that is needed in order to do that. And so when I say very likely, there's almost no way for that to be the case. But as a lawyer, I certainly want to say never. It's just that it's very likely that that's not going to be the case. So,
right. And then comes to, and that's the leading question to what's direct marketing and telemarketing.
Yes, exactly. What is direct marketing?
That's where it really comes down to, right? So from that perspective, you must collect information directly from the consumer. I mean, you do not have, you can no longer buy data, right? This actually implies that it will impact your marketing and sales processes. You must get consent. You must have the ability to provide the opt-out facility also, right?
Mm-hmm.
And obviously, customers and partners are exempt from this specific opt-in, right? But they would need the ability to opt out, even though they would have the ability to opt out for lawful processing, such as processing an order. You have the ability to send them communication and messages associated with the sale process or other things like service process.
Yeah, there's a distinction here. If you need to be contacting people because of, send them a receipt or inform them of delivery, that's something quite different. The one of the more common ways that a common sense way to think about this, I guess, would be to say was, should this person expect to be hearing from you, right? Do they know who you are as an organization or a company? And do they have reason to be getting contacted by you? And if the answer to that is no, then it's probably a good chance that you shouldn't be contacting them if they haven't in any way consented to that. So
that's correct. So having said that, let's talk more about the consumer privacy rights.
Yep.
There must be a way for you to provide consumers meaning any data subject. That could be your employees as well. That could be your potential customers. That could be your potential job candidates, right? Whoever you are interviewing, B2B data, that could be the executives within the customer's organization as well. That comes into play, right? All of them have rights. They have the right to opt in, opt out of direct marketing. They have the right to access data, which comes under the purview of POPI, and the right to know, right to connect, correct, delete, object to processing, etc. Right?
So, so 51 abantu abaparticipate in the workshop. 51 South Africans work.
Excuse me, I'm going to mute this gentleman.
Yeah.
Okay. So, having said that, how do you go about doing this, Brad? You need to respond in a reasonable time frame, and the limit given is 30 days, and you could definitely do an extension of 30 days, right?
Yep. Yeah. So if if someone makes a request, whether it be an employee or a consumer or something like that, they're a lot. They can make that request to you, and then you have 30 days is the minimum that you should acknowledge that, and then you can certainly extend that time period if it's particularly difficult question or something to that regard. So usually have up to about 60 days if you ask for the extension, but within that you need to be set up so that within that 30 days you at least need to be acknowledging it. And then asking for the extension if that's the case. So
So this should be part of your standard operating process whenever you process any specific request. And don't forget that you need to do verification also, right? If you're
Yep,
not verifying who the request came from and you're sending them the data, then you are potentially liable for a data breach
exactly.
because you sent it to the wrong person. And now you need to go to the breach notification process and all of that other stuff. Okay.
Yep.
So you got to have some level of process in place so you can actually show intent that you are actually doing the verification correctly. Okay. So that's a really important thing to note. Now, having said that, coming back down to breaches, they're expensive. It's going to cost you a lot of money. It's going to cost you time. It's going to cost you heartache and headache, right, Brad?
Yes.
You go through this all the, nearly every other week.
Yep. Oh yeah, it happens frequently. And so, I mean, the key here is that you are very likely, your organization is very likely to experience a data breach at some point in time. And so the question is just how prepared you are in order to be responsive to that. So, how quickly did you recognize it and were you able to respond to it? How organized were you in your response and notifying the regulator or the individuals? And then keep in mind, if you do have a data breach and there's an investigation by the regulator afterward, all of the other compliance aspects of what you're doing may also be investigated in terms of they're going to look more broadly at it. So, do some work to make sure that you're in compliance, not only to prevent breaches, but so that if you do have a breach, which is very often likely to happen, that you're able to demonstrate that you actually have a great compliance program. This was just an accident or one-off or something like that. So, because the accidents do happen. So
exactly. And obviously, you need protection from theft or intellectual property. There's a lot of things that could go wrong. We've talked enough about that, but we don't talk enough about this specific area. Okay.
Yep.
If nothing, we would recommend that you buy some type of cyber liability coverage. It's not very expensive to get cyber insurance,
Mm-hmm.
for POPI or other things unrelated also. Supposing, say, one of your employee loses their mobile phone and all the company data is on the mobile phone. That's a breach. You need to go through a process. You need to go through a plan and a process, and how do you respond to that? All of that stuff need to be in place. At the end, you still would likely need some kind of cyber liability coverage, so it doesn't overly burden you when it comes to the cost of any such thing, right? Now, having said that, let's talk about Essert now. How does Essert help? So we provide a software platform for compliance operations. Okay, so you could easily set up, you could streamline your processes, you could then manage. For example, you could manage annual reporting, you could manage the data subject request process, you could manage all your risks and see where the risks are. You could manage engagement with your vendors, third-party risk that you might have. You could actually manage all of that stuff, okay, and potentially mitigate some of the risks. If you can see what they are, you can go through a process and mitigate it. This is, having said that, okay, the risk is still going to be there. Nobody can completely eliminate the risk for you, okay? All the regulator is looking for is, have you done enough, okay, to mitigate the risks? Have you completely ignored it? That's a big red flag, right, Brad? You should not fully ignore it.
Right. I mean, there are any number, though I usually say it like this, there are any number of companies out there that are completely ignoring POPI right now. And if you're on this masterclass, you're not ignoring POPI. And so take the steps, there's a certain number of minimum additional steps that you can take to start demonstrating compliance, so that if the regulator comes to the door, you might not be fully compliant, you might not have everything completely done, but at the very least you can say we are making efforts toward it. And then that's a situation where you're a lot more likely to get a corrective action or something like that. The companies that are going to get fined are the ones that are completely ignoring POPI.
Right. Now, having said that, we have a lot of customers on the platform, and we've trained a number of experts who can help you with it. And I'll go through these steps to get compliant fast at no cost. Before I do that, let me just quickly go through what we provide, right? We have two packages for you, okay? One is the free package I will go through today in detail. And another one is the pro package, light package and the pro package. And that's what we differentiate and give you, right? In the light package, this is the easiest things to do and finish. You get a fully done privacy policy, customized to your requirements, and we will walk you through that. And you would get a PIA manual, which is similar to the PIA manual verbiage that usually the information regulator gives you, but then you need to fill in a few things custom to your company. So we would help you with that element of it. But our pro package includes a number of other things: the standard operating procedure for your data subject rights management, your employee privacy policy notice, the list of sub-processes which you'd also need to actually publish as a public document, as a public notice, your cookie policies, your digital media policies, your IT security policy that you need to follow within the company just to get started. You know, what is my IT policy, right? Social media usage policy. A really useful thing, an extremely useful thing, is your data breach incident plan. If you had a ransomware, what would you do? You should have a plan for it, right? And we also
Absolutely.
provide all the agreements that you need with vendors and stuff like that, right? So, Brad, you want to add? I mean, I think we've
Yeah, well,
we
and
provide a
the
lot of
incident, yeah, the
value in
incident response. Yes, one of the things that I like to stress about incident response plan, policies, procedures, any of that is to just say, like, taking the steps to think through those things, even at a very basic level, especially for incident response, goes a long way. Because if something is occurring, or if there's a situation that's arisen that you've mapped out in a policy document or procedure document, which we have templates for, it's a lot more calming to know that you have a piece of, a document that you can open and say, okay, we've thought about this, how do we go through it now, rather than just trying to figure it out on the fly. So,
and all of this, the pro package is just under 1,000 Rand a month, and you will get charged at the end of the month. As simple as that. Okay, this is the best value that we know in the market right now. Now, having said that, I've sold enough. I think that's 90 seconds of selling. Now, having said that, let's walk through this, the free package. So you can actually finish it, download your, we have the information officer registration form here. You could go to the information regulator and download it, or you could take this. They're exactly the same. It's no different. But it's in one place here. You download the form, send it, sign and send. And you need to know what data you have, what is the lawful processing of your data. We'll provide you a simple mechanism to actually check, and have it all there. So your purpose of data processing and the categories of data you process and the sources of data that you collect from are all clear and available to go into the PIA manual and to also go into the privacy policy. Okay, and then you would deploy the data subject access rights either on your website or have it available in such a way that if you don't have any website, there are other mechanisms that you need to follow. We can review that with you. Okay, so let's do a quick demonstration of that. But that's our sign up process. Once you sign in, sign up, you could do that using Gmail, Microsoft, or just an email address. Okay, and you will get a verification link. Once you get the verification link, you would be taken to an onboarding process. Okay, the onboarding process will start with, I have to log in again, I just logged out. The onboarding process would start with you selecting a goal. My screen would look slightly different and your screen would look a little different because you would be first-time user, and you would see four things here. You put California or some basic privacy compliance or a light POPI Act compliance or advanced POPI Act compliance. You could select the advanced POPI Act compliance to get all the other things that we discussed and more, okay? Or you could select the light POPI Act compliance. Let's just do that. And it will actually take you through it. At this time, because it's 0 Rand, it doesn't ask you for any credit card, nothing. So you can just go through this without any issues. You could review the quick presentation here and then get started, which is the step 1. And the step 1 is fill in some basic company profile information, like what's your company name, what's your physical address, do you have a website, and your company email address for somebody to get in touch with you, and the phone number, and who is the POPI information officer. If you don't have somebody designated as an information officer, we would recommend that you put in the CEO's name for now, okay? And all of this information is really important, okay? So the email address, why do you need to do this piece of information? Because this goes into your PIA manual and this goes into your privacy policy as well. So that's the reason, and that is by the law that that information needs to be published, right, Brad?
Right, exactly. So yeah, so that information, I mean, the key here is that that there is somebody responsible, so that if for example, I mean, I think the key here in the law is that if there's somebody that, if there is a complaint, that the regulator knows who to contact, right?
Right.
And that they're not just, and it also helps the regulator identify, is this a, if there is a complaint against somebody, is this a legitimate business, or is this maybe a scammer, or is this someone else? And then that allows them to help understand what type of investigation they might be undertaking.
Exactly, exactly. I would strongly recommend not to skip this. Just put it in and see. You may not deploy it, but see what the system helps you with, right? Just so you understand what you could do with it, right? And what is the important thing that you need to do. And then you, the second step after that is registering the information officer and deputies. And that you would do by downloading that form, the IO registration form. Now, I have been hearing from the regulator more frequently now, saying that they fixed the portal and you don't have to send in the forms, etc. Please do check it out if they fixed the portal. Sometimes it works, sometimes it doesn't seem to work, right? But we have all that information in this video. Where is the portal, where to send the forms, and the address to send the forms, etc. are all available on the video. I would recommend that you actually click through this video and find the information there. Otherwise, you can download the form and then write in and scan it and email it, right?
Yep.
And then the next step is going to be selecting your where you're storing your data, what type of data you're storing. You may be, I have some pre-selected because I've been using the system. You might have a CRM system. You might have an accounting system like a Xero or a Sage or Recruitee for some candidate recruitment process, things like that. Or if you have, mostly many companies seem to use Zoho or Microsoft Office 365, potentially Zoho again comes back here, right? So we recommend that you select them and add that to your catalog. What it does is the system, we are an AI-based system. Based on your selections here, the system has figured out what is the purpose of your information collection 99% of the time. If you're doing something slightly different, you would have the ability to go and modify that, okay? So you select the catalogs or the type of data that you do lawful processing of data that we are talking about. what are all your data stores, and then add that to the catalog. We'll have more than one in here. And voila, out comes your POPI manual, right? If you've changed the name of the company, you can click that here and change it, right? And it gets recreated and it gets input across your entire manual and becomes your custom manual, right? It's not just generic anything. So you remember, we put the company profile information, all that information is right here. This is a requirement by the information regulator on how the manual needs to look. The categories of records that you process, this is a requirement. Okay, you won't be, and this came from the catalog of data flows using our AI system, for example. And we talk about what type of records on each different subject that you hold, what type of purpose of processing. You're actually doing some research, you're processing privacy requests, you're administering pay and benefits, you're getting customer feedback. These are really critical that you need to plug in, right, Brad?
Yep, exactly. These are the things that you need. Like, it's common for people to think about, oh, we're, the customer side of things, but you need to be making sure that you're addressing all the systems that have employee data and what you're using those for, and knowing and having this record so that you have a clearly established a purpose under the law and all of those items, which is something that you really need to, which is a key part of compliance here. So,
and this all came from our system because you selected what type of data that you have, where is it flowing, how is it going, all of that stuff, right? And
exactly.
And so we put this all in the appropriate way and provide you and generate it for you. Okay, and that's it. Okay, you could download the HTML, put it on your website, or download the PDF and stick it on a bulletin board for your customers to see if you're a 2-person company, for example. But this is a public facing document. You need to publish it, right? So you would publish it and go next. It's very easy to do that. You don't have to worry about, oh, where is the POPI manual? How do I do it? Am I doing it correctly? All of that stuff don't come into play. Okay. And then hopefully very soon, system is processing its own stuff. We will come up with the privacy policy here. There it is. Okay. So we do create your custom privacy notice. Okay. And this is typically something that you would see on a website. So with most COSA websites that we have noticed, they don't have a privacy notice. Okay.
Right.
And this is as simple a notice that you can put in. Again, we created, because of our AI system, we created all of the information like purpose and categories of collection, etc. We put it in here, and we created an entire privacy policy for you that you could download or publish on your website. Okay, and you could actually push that publish button and done. Okay, so you had 3 big things to take away from here. You had the way to register the information officer, you had the POPI manual, and you had the privacy policy. Okay, now you can deploy it on your website using a WordPress plugin, which we provide. Again, that is also free, doesn't cost you a thing. And you deploy that and you can actually publish that in a public way. And we don't have enough time to actually go through the deployment on a WordPress website. You could send that WordPress plugin to your marketing team and have them deploy it, right? And having said that, that's it, it's done, right? Once it is done, you can actually go in and see what you actually finished, right? You finished all of these tasks: company profile, registering information officer, data flow catalogs done, editing a PIA manual, you could edit them and do all that. Edit the privacy policy, deploy your WordPress plugin, from the perspective of public disclosure. You could update your social media with the privacy link so it refers properly. And then you need to send the policy changes. Here is our PIA manual, and here is our privacy notice to all your customers, which you typically would send, right? And once you do that, you check mark that. That's your light POPI compliance. Done. By the way, if you do want to change the privacy policy or edit it, you can go back and refer to it. It's in the system. Okay. If you want to look at the data flows that you have, you can go back to look at the data flows and modify these data flows that you have here. Okay. Cool. Having said that, Brad, I want to take any questions before I go back to the presentation.
For sure. We do have we have quite a few that have come in. So there's a question on what goes into the annual report. I mean, that's defined in the law in terms of what needs to be in there. I don't have the details off the top of my head.
PIA primarily talks about how many records you process, what type of DSR requests that you process, etc. And the second thing that you need to have available is the impact assessment report.
Yep.
Okay.
Exactly.
You need to do an annual impact assessment.
Yep. And that's and the items to sort of address in there, you could use Essert to do that. It's consistent with what the law asks for on those pieces in terms of what you look at from an assessment standpoint as well. So it said. Then the next one is, okay, so all organizations are vulnerable to the costs associated with attending to complaints, including petty and invalid ones. I suppose in theory, I mean, I think that's part of having a well-documented privacy policy notices in that, because if there is a petty or invalid complaint submitted to the regulator, the easiest way to answer to that is to demonstrate that you're not actually out of compliance, right? So the regulator will parse those the same way as it would as any complaint that might come in around any regulator or police or anything like that. So let's see, is it only public bodies or also private bodies that everyone that needs to submit an annual report? I believe it's everybody that needs to submit an annual report. So that's on that piece, and whether that's different between the two. Again, we can't provide you legal advice here. There is an annual report requirement. The details of what needs to be in there, you could use the platform to help with that. Look at the law, consult with your attorney to see precisely what needs to be in there, but certainly don't ignore it. With many companies migrating to data to shared drives, does this give employers the right to access the personal private information of employees? I'd say generally what you do needs to be consistent with the notice that you have provided them. So if you're going to, and you need to make sure you have a clear purpose for accessing certain information. So if I'm an employer, there's certain information I need about employees in order to continue to employ them. And then there's certain information that I would never need, right? And so, so make sure that the information that you're collecting is tailored to that specific purpose. And then, and that you've informed employees what you're collecting from them and why you have it. And then if there's a shared drive situation, you need to inform employees that they shouldn't be putting information in there that is personal in nature, right? If it's a business situation, then they shouldn't be using they shouldn't be using a business shared drive to put personal information in there. So is there a way of checking if an information officer is registered with the information regulator? Yeah, there should be. Whether it is available at the moment, the regulator website is somewhat, you should be able to look up a particular business on the regulator website. I don't know if that's always available, because we've had this experience with the portal as well, where you submit the information. So you could certainly submit an inquiry to them if you had a question about it. But otherwise, if it's your own organization, ask internally to find out if something's been submitted before, because if you ask the regulator potentially and their information isn't in there, then you don't want to put your own organization at risk there. So powers of attorney, letters of authority documents have become quite popular lately as they enable information access by authorized representatives in their various capacities as a data processor that moves the targets focusing into these shortcuts. I believe the responsibility still lies on the data processor to verify validity, but how is it practical and cost effective? I mean, so yeah, there are, it depends on the circumstance, but yeah, power of attorneys and letters of authority are common. I know that there are websites like deleteme.com and those types of things. And it depends on the nature of it, because some of those, it depends on if it is a power of attorney and it is, say, the son or daughter of their parent and they're acting on their behalf to make a data request, that's one type. If it's a power of authority or power of attorney and it's a company like a web-based company where they are sending out notices and, delete requests to everyone, my default is usually to say, we need to confirm and verify identity with that actual person, because and it may depend on if the regulator issues guidance on what's a valid form of that authority or something to that effect.
I think the information regulator has yet to take a position on that, Brad, unlike in other jurisdictions.
No, they have not taken a position on it as of yet. That's why. No. Yeah.
So it would be, you as a business, you could basically say that's not a valid form, and you would still be okay with the regulator, in my opinion. But again, depending on the type of business you run, we would recommend that you actually get some advice on that. Yep. And it is tough. It's tough to verify this. It's definitely not cost effective, right? It's expensive to verify all of these things, to see if the power of attorney is valid,
right?
If the person is valid, and do they have the legal authority associated with it? That's tough.
Yep. A couple people asked, we will share that because they're having internet difficulties. We will share the recording. This has been recorded. You'll be able to watch it after the fact if you want to review anything. And if you can reach out to DV or myself if you have other questions as well. If a customer inquires about your product by completing an online lien form, how long are you allowed to keep their information and retarget the customer? I mean, it depends a bit on what it says on the form, right? For example, if you submit the form and as a part of that, you say, you have something that says you consent to us keeping your information to continue to retarget, then you may do so. Otherwise, if you don't have that, you can reach out certainly that one time or consistent with sort of the purpose of reaching out. But this is where privacy policies and notices and consents really come into play. It depends on what it says, what that web page says when they actually sign up. So in terms of how long you could keep it. But the key is, as long as either they have consented to or you have a business purpose to do so, right?
Yeah.
And if it's direct marketing, you can't rely on a business purpose forever. You need to be going back to that consent. I'm saying business purpose is if let's say they say, I want you to contact me, you contact them. That's they've actually made that request, and then they make an order, then you can keep going. But so it depends on that.
Yeah, but there is, from a business angle, I'll take a slightly different view also on this. You cannot store that information forever or process that information and keep sending that person direct marketing messages saying, oh, we have a new laptop for you to buy at 50% off. Reasonable time could be 30 days in your mind, it could be 90 days, it could be 1 year. So long as you set up policy for it and have a written down policy, that's the useful aspect of it. Okay, so keep in mind that just in case you get a letter from the regulator, they're going to look for things like that. What is your standard operating procedure? Are you going to keep the data forever? Do you provide an opt-out capability? Right? That's the key out there.
How do I become an information officer? Can I get a job as one? I would say educate yourself about
the company.
Yeah, I would say if you take some courses about becoming being privacy compliant, and you certainly apply for those jobs. That's an internal role. Usually, you could explore being a consultant and supporting privacy officers as well. But there's it is a job, and my guess is it's going to be a job going forward. It's a job in many jurisdictions where there's privacy sensitive. So
it is.
How does protection under POPI affect cessation of debt to creditors?
It does not.
I mean, in terms of the it applies to how your personal information is used. It won't affect your actual debt or anything like that. That would be governed separately. Now, for some reason, under a different law, you were, you had debt forgiven, or the debt was no longer valid to be collected. There might be reasons that they shouldn't be contacting you, but I can't necessarily predict the interplay between those two. But it doesn't actually change any sort of credit debt issues. So
I think on nearly every masterclass we asked some kind of debt collection question that we have seen. So if you're asking from a consumer perspective, you'll have the option to opt out of direct marketing emails coming from the debt collector, which means that they can't send you any information outside of the preview of the collection process itself. Number one. Number two, the debt collectors cannot sell your information to somebody else, so they can keep calling you from a direct marketing perspective, which is a portion of their business. That business of selling data is just now completely gone. That's illegal to sell that data and information. But there is a charter, I believe, where the debt collectors could share information with financial services companies from credit ratings perspective. So there is a separate charter on that, right? So that is a possibility, that whether the debt is fully collected, fully paid off, reported, not paid off, et cetera, how much time it taken, all of that information is being shared. So your credit ratings actually get associated with it. Okay.
Yeah, I mean, the reality of it is, as with any of these privacy laws, there will be interplay with other laws. Employment law is also a common area where there's some sort of interplay. And it just depends on what the data is. And you're probably, if it's getting that complicated, you need to be probably consulting with an attorney. So
correct. So I dropped a link for the free Kindle book. It's only available today. So please click that and get the link and download the Kindle. It doesn't cost you anything today. Having said that, I would also suggest that if you want more specific information, or you want us to walk you through the light POPI Act compliance work list, walk you through that process, and if you're having some difficulty about it, you could schedule a meet with me, and I'm just going to drop and this would be directly with me, and just click that link and take a 15-30 minute slot to go over any questions there. Okay. Having said that, anybody has any other questions? Or Brad, can we do a wrap?
Yep. No, that's let me just verify here. I don't see any other questions in the chat, so I think we're good.
Excellent. So a few top items. Do sign up onto essert.io, essert.io. It's free to sign up, free to start your light POPI Act, free to download your privacy policy, PIA manuals and all, and even deploy them on your website, number one. Number two, if you need any, please download the Kindle. That link is in the chat as well. Also, set up a meeting. If you want to talk further, do set up a meeting as well. And we'll be happy to answer any of your other questions. We will send out this recording to you guys in the next few hours. So you would have the whole recording available for you. Okay. And thank you very much for participating.
Thanks,
and
everybody.
best of luck. Thank you, Brad.
Thanks, Evie. Bye.